Hello, good morning, good afternoon, good evening, everyone. It's an honor to welcome you all today to a webinar on abuse of dominance and sustainability, co-organized by the OECD and the International Chamber of Commerce. As you may know, this is the third webinar in this series that the OECD and the ICC have jointly hosted in the last 3 years, exploring the potential relationship between competition law and climate change and sustainability. In that context, we have identified clear links on how sustainability may play a role in relation to cooperation agreements, where certain collaborations may be relevant to achieve environmental objectives. Furthermore, we have seen how similar principles and consideration may apply in merger cases. Today, we want to shift the focus of our discussion to another potential critical topic, namely the relevance of sustainability under the abuse of dominance tool. In this context, however, the questions appear to be far less clear and potentially even more complex compared to the other two areas of competition law. In recent years, we have seen two significant developments that are increasingly converging, potentially reassessing the role of competition law, the role that competition law may play in shaping not just markets, but also our society as a whole. First, there's the growing concern over market concentration and increased market power. Dominant firms in many industries and sectors, including digital markets more recently, have achieved significant influence and power, which may have the potential to restrict competition and negatively affect consumers. Second, we are facing with undeniable urgency of climate change. By looking, for example, at the Paris Agreement of 2015, the EU Green Deal's objectives of 2019, and the 2023 Agenda for Sustainability and Development, and indeed the ongoing debates across jurisdictions around the world, the sustainability agenda is becoming more and more of a priority. In this context, there seems to be a growing interest to determine whether first there is the need to bring these two developments together in a consistent manner, and if so, how abuse of dominant tools can be used to address unsustainable practices by dominant firms. Some argue that abuse of dominance rules should be interpreted more broadly in a way that supports sustainability initiatives, even when dominant firms engage in certain practices that may otherwise raise competitive concerns. Others are more cautious, emphasizing that while regulatory intervention should be used to address unsustainable practices, it should not allow sustainability efforts to become a pretext for reinforcing market power. The real challenge may ultimately relate on how to strike the right balance between preventing market concentration, in particular dominant firms from abusing their market power, and encouraging long-term thinking for sustainable development and green future. The objective of today's webinar is to open a debate on these issues and to explore the complexities and challenges of these potential relationships, i.e. sustainability and abuse of dominance, and balancing exercise by hearing from experts in competition law, economics, and sustainability. Some of the issues that will be discussed today here are: what have climate change and sustainability got to do with monopolies and the laws controlling abuse of dominance? How and to what extent can abuse of dominance tools be utilized to tackle unsustainable practices by dominant firms? How can competition law promote the innovation and investment needed to drive sustainability goals? And the recent review of the 102 guidelines by the European Commission. So thank you very much. And moving now to the next part of the agenda and presentation of our esteemed colleagues and speakers. And now I will give the floor to Giorgio. So Giorgio, over to you.
Thank you, Ori, for the introduction and opening remarks. Good morning, good afternoon, I would say even good evening, everyone, and welcome again. I'm Giorgio Castaldo, currently working as a competition expert at the OECD Competition Division, and it's a great honor and privilege to moderate what I believe will be an interesting and stimulating debate on a key topic. The agenda today is divided in two parts. We're going to spend the next 30 minutes hearing the views from three experts, namely Elise Provost, Sustainability Network Head and Advisor to the General Rapporteur at the Autorité de la concurrence in France. Elise will set the scene and provide an overview on the relationship between sustainability and competition policy. Then we will have Vera Pozzato, Senior Policy Officer, DG Comp, European Commission, who will present the Commission review of Article 102 from a sustainability angle. Professor Simon Holmes, Chair of the International Chamber of Commerce Taskforce on Competition and Sustainability, also one of the key organizers of this webinar, who will introduce today's specific topic on the use of Article 102 and national equivalents to tackle unsustainable practices. We will then move on to a panel discussion focusing on recent developments in sustainability and competition policy. The panel will include experts from the academia and competition authority, namely Professor Wolf Sauter, Vrije University, Amsterdam, an expert from the Netherlands Authority for Consumer and Markets, Professor Deborah Healey from the University of New South Wales, Australia, Professor Michel Meguer, Senior Policy Fellow at the UCL Center for Law, Economics and Society, and last but not least, Professor Martin Peter Schinkel from University of Amsterdam. At the end of this panel discussion, which will last around 50 minutes, there will be a 10-minute Q&A session where we will select a couple of questions from the audience. You may add your question directly in the chat, specifying also from which speaker you would like to receive the reply. By reminding now all the speakers to be concise in their intervention, I give the floor to Elise and wish everyone a pleasant beginning.
Thank you very much. I have the pleasure to introduce today's discussion with a rapid overview of the relationship between sustainability and competition law and competition policy. But before we delve into the substance, I would like to express my sincere gratitude to the OECD, the ICC, and Simon Holmes in particular for giving us, for the third time, the opportunity to discuss the interplay between sustainability and competition policy. Why this discussion is so important? Well, the obvious reason is that sustainable development represents both a major and a pressing challenge for our societies. Against this background, a growing emphasis has been placed on competition policy and on the part that it should play to support environmental and climate objectives. The relationship between sustainability and competition policy has evolved considerably in recent years. A few years ago, when the question of the interaction between sustainability and competition policy began to emerge, the debate centered on whether we, as competition lawyers and competition agencies, we should consider sustainability objectives as competition policy objectives. We spend a lot of time discussing the place of sustainability objectives in the treaties, the need to reconsider or alter the traditional objective of consumer welfare, and so on. Also fascinating, this theoretical debate was overtaken by a much more practical approach with a large consensus on the following. First, competition law enforcement by itself protects and promotes innovation, quality, diversity of products and services, and efficient use of resources, and then a move toward a more sustainable economy. Second, sustainability considerations are becoming competition parameters, and for that reason, they fall into competition law assessment. In addition, one should note that while the subject remains highly politicized in some jurisdictions, a majority of competition practitioners, and perhaps more importantly, of competition authorities, now consider that we need to work on sustainability considerations. They have set up dedicated teams, working groups, are trained on environmental economics, and so on. For instance, last July, during 2 days, the French Competition Authority hosted the first ICN workshop dedicated to sustainability. On day 2, we had an agency-only event with about 80 officials from all over the world, discussing with each other on capacity buildings, tools, difficulties with ex-ante assessment, etc. That's a clear, positive message. That being said, there are still important discrepancies among jurisdictions, which is regrettable given the urgent need for global response to climate and environmental crises. If we go into a little more detail now, one should note that our work has been very heterogeneous. On the cartel agreement side first, here, the work has been very important. You may have seen that several jurisdictions now have dedicated guidelines on green agreements in order to help businesses to drive nice cooperation and sustainability. Several agencies have reoriented or even set up ex-ante informal guidance procedures in order to assist undertakings by providing them with greater legal certainty. We now have precedents from different jurisdictions in Europe, but outside the European Union as well, on which firms can rely to drive their own cooperation and sustainability matters. Lots of work remains to be done, of course, including to achieve a consensus among jurisdictions on crucial points such as out-of-market efficiencies. But one could say that we laid solid foundation to take into account sustainability considerations and promote lawful green agreements. If we move on to the merger analysis side now, the work might be less important, but also less visible. Nonetheless, competition agencies take into account sustainability considerations as they potentially affect market definitions, for instance, or assess whether a given merger may affect not only the capacity of undertakings to innovate, but also the direction such innovations may take or no longer takes due to the merger, and then assess what we could call the risk of green killer acquisitions. Academics have also started to work on sustainability and mergers, and I'm sure future reviews of merger guidelines will give the opportunity to better explain how sustainability considerations may integrate competition analysis. But if we go to the abuse of dominance side now, it's clear that the work is in its infancy. Our speakers will develop why and what we could or should do, but one could already know that. The reason why the work on abuse of dominance has been less developed are at least twofold. The fact is that there is no causality or no direct causality between unsustainable practices and dominance as legally defined. The second reason is that firms, businesses, are largely at the starting point of the discussion on the interplay between sustainability and competition law. And yet, they have not raised the issue through the abuse of dominance angle, but rather through the need to cooperate among competitors. This does not mean, of course, that there is no room for abuse of dominance rules as far as sustainability is concerned. Why? First, and from a factual point of view, although only few unilateral practices that impact sustainability can be caught under abuse of dominance provision, they may have a significant impact on sustainability, and more importantly, their prohibition may deter important firms to pursue other unsustainable practices. The second reason is that, on the other side, moving towards sustainability by an entire sector, thanks to trade associations or NGO initiatives in particular, may be extremely difficult when one undertaking is a dominant company due to the risk of abuse of dominance infringement. This clearly calls for clarification on the interplay between sustainability and dominant firm behavior under competition law. And the last reason is that from a theoretical point of view, what works for agreement cartel policy should work for abuse and abuse of dominant policy. This is true in terms of theory of firm, and here the exploitative abuse category is of course relevant, but it should be true as well in terms of justifications. The good news is that in practice, we can see a slight move that is encouraging. On the sword side first, we have already cases that were not clearly identified as sustainability cases, but could enter the category. Here, for instance, I could mention the Engie case where the French Competition Authority accepted commitments from the gas incumbent to withdraw a gas inlay provision in its contract, preventing customers to use a mix of energy and solar energy in particular in condos. We have also ongoing cases at the CAT level in the UK, the water case, before the Italian agency, the bioplastic producer case, but also, for instance, at the EU level with the ongoing case on electricity prices in Greece. If we now go on the shale side, we do not have clear case so far, although at the French Competition Authority, we like to mention the Cistercian congregation case, where we found that limiting the number of tourists in an island through lending exclusivity granted to a shipping company might be justified by the need to protect the environment. But if we do not have clear case so far, this does not mean that the question is not important, and agencies have understood that there is a potential need. For instance, the Japanese agency has inserted some development about abuse of superior bargaining position in its guidelines, and the French Competition Authority, for instance, has explicitly opened the door for informal guidance to dominant firms. That being said, lots of work remains to be done on how to integrate sustainability arguments into abuse of dominance analysis. To conclude this introduction, I'd like to mention a few paths that could be explored. Should we interpret the concept of competition by the merits as requiring sustainable competition? Should we, for instance, integrate the fact that on a long-term basis, the cost of many inputs will be far higher than they are today? Think about water, packaging, transport, and so on, and that this should be reflected in our analysis, and in particular, in the determination of the incremental cost when assessing exclusionary price practices. On the other side, we should also explore when a sustainability consideration may be raised by a dominant firm to explain, to justify its behavior, such a refusal to supply, for instance. I will not develop this point in this introduction, but I'm sure the other speakers will provide some relevant arguments that will largely address them. And to some extent, the current review of Article 102 at the EU level that Vera will now present may be a relevant tool to address some of the points I've just raised. Thank you very much.
Thank you very much, Elise, for this exhaustive introduction and overview. And I now give the floor to Vera.
Yes. Thank you, Giorgio. Thank you, Elise. And thank you to the OECD for inviting me to talk today about the draft 102 guidelines on exclusionary abuses of dominant position that we published for consultation on the 1st of August. The European Commission published on the 1st of August in connection with the topic of sustainability. I would like just to stress at the beginning that I'm speaking in my personal capacity and that whatever I say cannot be considered as attributable to the European Commission as an institution. So the discussion on the interplay between competition policy and sustainability has been mostly focused, as we've heard already, on agreements between competitors. But there are now discussions and a lot of issues raised also in the area of abuse of dominance. So as a first point that I would like to make by way of introduction, just to explain what the mindset, what the thinking at the level of the Commission is that I believe sustainability considerations are and can be folded in our competition assessment in abuse cases, but to a certain extent. First, sustainability can be a dimension of quality and innovation that has an impact on consumers' choices. And its relevance could therefore influence market definition and subsequently also how dominance is established. If a certain product is a more sustainable product is considered to be non-substitutable, substitutable with other products, then dominance might be more easily found, for instance. And this is also depending on consumer willingness to substitute a given product with another one. On another point, in another aspect, it has been suggested, in particular in an academic area, that the possibility for a company to behave unsustainably in the market should be considered as an indication of dominance in itself. I wonder if this is a good idea, and I also wonder if we take the sustainability aspect out of the picture in this case and we think about it, would we say that a company can be found to be dominant simply because it produces, for instance, very low quality products? In my view, I see this that this can be considered as a possible manifestation of lack of constraints by competitors in this situation, and can certainly be taken into account in analyzing the market characteristics, but cannot alone be determining a finding of dominance. Moving on to the analysis of conducts, if we look at conducts, one could consider, for instance, that for more classic types of abuses, the possible anti-competitive effects could also entail a sustainability dimension. A dominant company's conduct could, for instance, harm competition through its capability to reduce the quality or availability of sustainable products, for instance, by refusing to supply sustainable input to downstream competitors, or through exclusive obligations closing off channels of sales for innovative and sustainable competitors. In all of these scenarios, the principles of our analysis under Article 102 would not be changed by the sustainability dimension. We have really not seen so far cases where sustainability-related aspects would require a substantial revision of our approach to the analysis of abusive conduct. Let me now move on and say a few words on the draft guidelines that we have published. They are focused on exclusionary abuses. They are based on the case law and enforcement practice of the European Commission in applying Article 102 of the treaty. The objectives of these guidelines are threefold. First, we want to fill the current gap in the Commission guidelines toolbox. As you certainly know, Article 102 is one of the few areas of European competition law where there are no general guidelines so far on the state of the law, although the enforcement of 102 is key to ensure that consumers can reap the benefits of competitive markets. You may remember that the famous guidance paper of 2009 was a priority setting paper. It does not constitute binding guidelines for the Commission. Second, we see that there is a need to systematize the very rich and complex case law on Article 102 to ensure predictability and facilitate self-assessment and compliance by companies. We are looking at around 40 judgments in the past round about 15 years on exclusionary abuses. The case law has inevitably developed incrementally, and judgments are not always entirely clear and consistent with each other. So there is a need for the Commission to provide clarity and legal certainty about how this body of case law comes together. The result of the call for evidence, some sort of introductory consultation of the public, clearly indicate to us that our stakeholders support this approach. Third, the guidelines promote a workable, effects-based approach, which is grounded firmly in economic thinking and at the same time conducive to a robust and effective enforcement of 102. As you probably have seen, the draft guidelines have a structure that follows the building blocks of the normal analysis of a conduct by a dominant company, establishing dominance. We indicate what, in a view, are the general principles needed to establish an abuse. Therefore, we articulate the analysis along the two legs: competition on the merits and capability to produce exclusionary effects. We analyze the specific legal tests that have been developed in the case law. We analyze the situation, the conducts for which the court has provided indications of the criteria to look at when analyzing such conducts. And then the last section is on objective justifications. Now, more specifically on sustainability. As we all know, there is very limited experience in the area of sustainability and abuse of dominance. So it is not surprising, in my view, that sustainability aspects are not particularly relevant in the guidelines. As is the case for exploitative abuses, a specific discussion would be premature at this stage, as enforcement experience in this area is still developing. However, there are 2 points of the guidelines that I would like to highlight as they have a connection with sustainability. First is the definition of the concept of consumer harm. And second, the last chapter dedicated to objective justifications. The relevance of sustainability in relation to the concept of consumer harm pertains to the offensive dimension of the concept, if you will. In certain cases, if sustainability is harmed, also consumer welfare can be harmed. The concept of consumer harm, and the guidelines repeat this, has a broad meaning in EU competition law. The draft guidelines expressly refer to the concept of harm contained in the market definition notice, which we also recently revised. And the term quality in the draft guidelines should be understood as covering all the various aspects related to the quality of a given product, including its sustainability, resource efficiency, and durability. Therefore, a given conduct by a company could be found to be abusive if it is capable of having anti-competitive effects, such as restricting the availability of more sustainable goods, more energy efficient goods, more durable goods, or also hampering the possibility for competitors to develop innovative and environmentally friendly production processes. These are all dimensions that can be taken into account in the assessment, and the guidelines open the door to this. As Elise already mentioned, the recent Greek electricity case is a clear example of this. In this case, the Commission has adopted a statement of objections against the supplier of wholesale and retail electricity. It is a predatory pricing case. There, the dominant company, PPC, supplied electricity produced through thermal sources, so lignite and gas-fired plants, at a price below variable cost in a way that deterred investment into alternative and more environmentally friendly energy sources. So this is the dimension that was analyzed in that case, while remaining within the framework of predatory pricing. As for the objective necessity aspect, this pertains to the defensive use of sustainability, of course. As you might have seen, what is relevant for today's topic is the reference in the draft guidelines to the possible objective justifications, such as the protection of dominant undertaking from unfair competition, or the reference to public health or other public policy considerations. So these type of justifications could cover sustainability considerations. And these are and this is derived from a body of case law that is not so developed on objective justification, admittedly. However, what is also important to note, and this is also based on the case law, is that the guidelines specify that it is not the dominant undertaking's task to take steps on its own initiative to eliminate products which, rightly or wrongly, it regards as dangerous or as inferior in quality to its own products, nor more generally to enforce other undertakings' compliance with the law. In other words, it would not be possible, according to the principles spelled down in the guidelines, to justify an abusive conduct by claiming, for instance, that the dominant company must act in a certain way to stop the production or distribution of unsustainable competing products. In the exclusive dealing older case law, the court also has told us that it is not the role of the dominant company to decide how many competitors should be allowed in the market. The draft guidelines also note that a possible objective necessity defense may be accepted only if the actual or potential exclusionary effects resulting from the conduct are proportionate to the alleged necessary aim. The proportionality condition is not met where the same aim could be achieved through means that are less restrictive of competition. And last point, in principle, also sustainability-related efficiencies can be claimed by a dominant company as a defense. In any case, to prove an efficiency defense, the dominant undertaking must show to the requisite standard that the 4 criteria are fulfilled, and these are the classic criteria, the 4 cumulative conditions. The first is that the efficiency gains result from the conduct, and that they are and the efficiency gains counteract any likely negative effects on competition and on the interest of consumers in the affected market. That those gains have been or are likely to be brought about as a result of the conduct, that the conduct is necessary for the achievement of those gains, and that the conduct does not eliminate effective competition. These conditions clearly recall the conditions for exemption under Article 1013 of the treaty, which are related to prohibited agreements. What we can say at this phase is that there is not big practice in this field, but as we developed our practice, we will see if these type of sustainability efficiencies are brought forward by dominant companies as justification for a conduct that is liable to be abusive. In any case, the burden of proof for objective justification lies always with the companies that are investigated. To conclude, I just would like to say that the draft guidelines faithfully reflect the status of the case law so far. And we've asked for feedback from the public until the 31st of October, and we will review this feedback, and we will see if then the text will need to be fine-tuned as a result. Thank you.
Thank you very much, Vera. As you said, I'm sure we are just at the beginning of this debate, and the interest will grow even further once we will have more cases. You mentioned one, the Greek case, but today and even in the future, perhaps today we will mention others, and in the future we will have more cases to talk about. So now I give the floor to Simon so that we can introduce this specific topic of today. Please, Simon.
Thanks very much, Giorgio. Well, first of all, I plead guilty to being one of those people who've been saying for some years that we need to take sustainability considerations into account when looking at abuse of dominance. And I think of a wide range of things that could be relevant here, in depending on the circumstances, whether it's burning toxic waste, dumping pollutants in rivers, using child labor, paying starvation wages, or cutting down the Amazonian jungle. Everything is context specific. Of course, I agree with others that this law and practice this area of law and practice is underdeveloped. However, it's long been recognized, and it's indeed by the courts, that dominant companies have a special responsibility to behave well, and that the categories of abuse are not fixed. And furthermore, we've seen in recent cases that these legal tools are very flexible. Look at the way it's developed into things like disparagement of competitors. And I see no reason why the sort of practices that I've just mentioned, which the average person would see as inherently abusive, should not be recognized as such by the law, providing, of course, the appropriate tests are met. In other words, we can use competition law as something of a sword, or this is the offensive side, which Vera referred to, as a sword to attack unsustainable practices to facilitate the transition towards a sustainable economy. And this is particularly the case, I think, where the practices in question are inconsistent with legally binding norms in relation to climate change, or with internationally recognized, inconsistent with legally binding commitments, or with internationally recognized norms and reports. And I think of those of the International Energy Authority or the powerful reports of the IPCC setting out what needs to be done to transition to a sustainable economy. One example, which I've used before, is if a dominant company avoids the costs of disposing responsibly of waste products, perhaps by dumping them on land or throwing them into the river, while its smaller rivals dispose of those in a responsible manner. Inherently, one sees this as exploitative, but it's actually exclusionary because it's it's avoiding costs which the non-dominant companies are incurring. It has an exclusionary effect. And of course, what we're talking about here, get it in context, we're talking about using the competition sword to complement environmental and potentially social sustainability regulations, either because the regulations are absent or, equally likely, because they're not being enforced properly or indeed at all. So I ask myself the question, where have we got to in this area? Well, first of all, I would acknowledge and agree with Vera that there are relatively few decided cases. Interestingly, the Italians seem to have had the most interesting cases, in my view, so far. The Socorapla case, where the Italian authority fined a plastic supply chain consortium some 27 million euros for abusing its dominant position in the market for the recovery and recycling of plastic packaging for food use. And it noted that the abuse there was not only preventing, its intervention not only prevented harm to competition, but also contributed to the achievement of environmental goals linked to recycling and waste management under both Italian and EU law. It's a clear connection between the environmental aspects and the competition aspects. In the Google NLX case, it was environmental factors were a factor in the quantum of the fine. There, the Italian authority fined Google just over 100 million euros for refusing interoperability with its dominant Android operating system to an app that allows drivers of electric cars access to a range of charging vehicles. And the ICA said it took into account in its fine possible negative effects which could occur to the diffusion of electric vehicles, to the use of clean energy, and to the transition towards a more environmentally sustainable mobility. Again, you're seeing the competition aspects and the environmental aspects interfused. There are, however, several pending cases, one of which has been mentioned by both our speakers so far, and that's the Greek lignite case. And I certainly think that's one to watch. The Commission's comments in its statement, its press release for the statement of objection there were interesting, because they said that this was deterring investment into more environmentally friendly and energy sources. And not only may this lead to higher prices for Greek consumers, it could lead to higher emission levels and local pollution. Again, you're seeing the environmental dimension and you're seeing the competition dimension. And then there's the UK water case, which Elise briefly referred to. We've got a series of collective actions in the Competition Appeal Tribunal, and I should disclose that I'm a member of the CAT, but I'm not involved with this, and I'm speaking purely from public information. The action is against several water and sewage companies, and the allegation is that these companies have infringed what we call the Chapter 2 prohibition, the UK equivalent of Article 102, by providing misleading information to the relevant regulatory bodies in relation to pollution incidents. And the quantum of pollution incidents is relevant to how much the authorities then allow the water companies to charge consumers. And the claim is for over £1.5 billion. So that's what, between 1.5 and 2 billion euros. And it's on behalf of some 30 million consumers, over 30 million consumers. Now, both of these cases are interesting in this respect. Although myself and others would say there is scope for developing new sustainability abuses, we often don't need them. We can tackle sustainability issues using conventional abuses. In the water case, it's largely about misreading a regulator, which was a new abuse back in the day of AstraZeneca, but now is well established. And the Greek lignite case is essentially, as Vera said, a predatory pricing case, and I would agree. There's another Italian case pending, which I think Elise indirectly alluded to. I won't go into it. It's a Novamont case in the area of bioplastics. But I did think that the statement by the Italian authority illustrates the interplay between competition policy and sustainability. What they said was safeguarding an open competitive process in the bioplastics sector helps achieve the environmental protection objectives pursued by European and domestic legislators, since it could encourage alternative and more efficient bioplastics, since it also favours, from a dynamic point of view, the development of cheaper or better quality eco-compatible products. Again, you see this interrelationship between environmental objectives and competition objectives. Probably we're going to see fairly conventional applications of competition law, but in a sustainability context. So where have the guidelines got to? Vera has clearly already introduced those. I'd make two preliminary observations. Like a number of people, we're disappointed that it only covers exclusionary rather than exploitative abuses. I won't go into the reasons for that, but the point I would make is that, yes, many sustainability problems are inherently exploitative of nature and fellow human beings, but they are often exclusionary. So although it's a whole, it's not perhaps as big a whole as I initially feared. And secondly, I would like to see a specific section on sustainability. I don't accept the argument that the Commission, that the absence of a lot of experience is a sufficient reason for that. The Commission introduced, quite rightly in my view, a new chapter into its horizontal guidelines on cooperation agreements without having lots of experience in that area. And that has been extremely helpful and will be very much a benchmark for people going forward. I'd like to see something in the Commission leading in this area. But all is not lost. I do think, and I'm positive about the generally very positive about the guidelines. It contains a number of what I call hooks, and I think Vera used a similar expression, by which sustainability considerations can be taken into account. The first of these hooks is the one Vera mentioned, that they confirm that quality covers all aspects relating to the quality of a given product, such as sustainability, resource efficiency, and durability. And I would add the image conveyed and the resilience of supply chains. That's extremely useful. Two others which I have identified. The second one is that the concept of competition on the merits may take into account all the legal and factual elements, and that includes the specific features of the conduct at stake. Now, it seems to me that if the conduct in question offends against any sense of decent behaviour or is contrary to internationally accepted norms, it is certainly a relevant factor when looking at that behaviour. And thirdly and finally, the guidelines say that when looking at competition on the merits, the specific circumstances of the case and the relevant factor can be, maybe, where the dominant company violates rules in other areas of the law where this affects a relevant parameter of competition, including quality or choice. 2 points there. Yes, affecting quality or choice, so that brings all the elements in which to which Vera referred a moment ago, including sustainability. But I would actually like to see a specific reference there to sustainability as a relevant parameter of competition. And secondly, although the example given of other areas of the law in the guidelines is data protection, for obvious reasons, I think one thinks of the Meta case, but this could is equally relevant to environmental or other sustainability rules of law. Finally, the two positive points I take, they're very general, but I think they're important. One is that the guidelines remind us that the list of practices set out in the text of Article 102 are just examples and does not exhaust the methods of abusing a dominant position which are prohibited. But I think that's very clear from the way the law has developed over the years and will continue and should continue to develop, including the potential for sustainability abuses. And the second positive I take is that, yes, it only explicitly covers exclusionary abuses, but it says clearly that the principles which are set out there are also relevant to the assessment of other forms of abusive conduct, such as exploitative abuses. So in the circumstance where perhaps some particular potential abuse or some abuse is exploitative in nature and perhaps not on that occasion exclusionary, one can use the guidelines and they could be very helpful. So my conclusion, 3 points in conclusion. One, yes, I would like to see a specific section or sections on sustainability to draw this together, given its importance. Secondly, and positively, I see nothing in the guidelines that undermines what we've been trying to achieve in terms of taking sustainability into consideration. And indeed, I see several positive things which are natural hooks or means by which that can be done. Final observation, yes, we're talking, I'm conscious that we're talking about Europe, European examples and European guidelines, draft guidelines of the European Commission, but and this is a global issue, but I do believe that the practice in Europe will influence things in other parts of the world, and indeed, and that's another reason why I would like to see something more explicit on this, because I know that the European Commission's guidelines on horizontal agreements is being cited throughout the world, and similarly, the Commission, the Brussels effect, if we had something on sustainability in these draft guidelines, I think it would be very powerful. Thank you very much.
Thank you very much, Simon, for introducing this specific topic on abuse of dominance and sustainability. You also provided additional cases that are also pending, and we know that it's going to be a long journey especially because the examination of dominance, market power, and abusive practices is already not easy, and this sustainability angle might add some more complexity. But we will see. You also mentioned your last comments before the conclusion were for the guidelines, the draft guidelines, and what we heard from Vera. I'm sure that the next speaker, so the panelists, will have also some comments on the 102 guidelines. So before giving the opportunity to Vera to react, I would move on to the panel for their initial remarks, giving the floor to Wolf Sauter. Please, Wolf.
Thank you, Giorgio. I'm honored to fill in for Martijn Snoep, although I cannot do justice to the richness of his views, obviously. Because I'm not the president of the ACM and speaking in a private capacity, I may also be less diplomatic than he would be. My observations focus mainly on EU law, especially on the application of Article 102, but they may apply in parallel to other jurisdictions with comparable provisions. First, a few words on the relevance of dominance abuse to sustainability. I agree with the view expressed by other speakers today that sustainability considerations can play a role under abuse of dominance as sword and shield. This applies to exclusion, Think, for example, of predation in relation to competitors who are taking externalities into account by dominant operators who ignore externalities. It also applies to exploitation. Think, for example, of violations of legal norms in relation to climate change that entail harm to consumers. In addition, it applies to the combination of exclusion and exploitation, for instance, in limiting the production of IT products that can be refurbished, which is being investigated in the Netherlands. But are we currently ready to address these concerns in EU law? This question requires me, second, to address the draft Article 102 exclusion guidelines. Although the guidelines are to be welcomed as such, there are in many ways a missed opportunity when it comes to sustainability concerns. The only explicit mention of sustainability I could find is a footnote as an elaboration on the concept of quality. As was just noted by the previous speaker, there is no sustainability section, unlike the one that is found in the horizontal guidelines. There is no extension of the sustainability principles for efficiency that were introduced under last year's horizontal guidelines. The efficiency exception proposed for 102 is different from that under Article 1013 and the sustainability chapter in the horizontal guidelines, and that leads to a proliferation of competition standards that is both, in my view, unhelpful and not justifiable. Also missing is a clear steer on the exception for legitimate objectives under the objective justification, and that could have been done in line with the vouchers approach that has often been advocated under Article 101. The guidelines do contain references to the meta judgment that Article 102 can apply to the infringement of rules that pursue different objectives. This may at least partially fill the gap on legitimate objectives that I've just noted. Finally, the 102 guidelines do not contain guidance on the relationship with the Corporate Sustainability Due Diligence Directive, the CSDDD, which requires undertakings to act in the vertical dimension. Such actions can include refusals to deal and boycotts. Hopefully, these flaws will be remedied in the final version of the exclusion guidelines. The background, beliefs, and brief of future Executive Vice President Vera suggests she may promote more effective competition enforcement concerning sustainability, and that will hopefully involve making clear statements to promote legal certainty, including by means of Article 10 decisions under Regulation 1/2003. And finally, my final point, I want to plead for private enforcement of sustainability norms. Some commentators on competition law and sustainability believe firmly in the primacy of government action and in relying on public enforcement of sustainability norms. Now, having worked in public law enforcement for over 25 years, I am considerably more skeptical of this, especially in view of the urgency of promoting sustainability. Therefore, I think it's necessary to allow not just standardization agreements, but compliance agreements between firms as a form of private enforcement, especially where there are first mover disadvantages. Similarly, I believe even dominant firms should be allowed to enforce public standards privately and ex ante, because ex post public enforcement of these norms is in many instances too little, too late. It's just not effective enough or non-existent. Obviously, this requires new thinking, procedural guarantees, and active supervision. Applying the CSDDD under supervision of competition authorities will provide a good opportunity to gain experience with such private enforcement. And hopefully the revised 102 guidelines will do that as well. Those were my opening remarks.
Thank you very much, Wolf. I now give the floor to Deborah.
Well, good evening. Obviously, it's extremely important for competition law to focus on encouraging sustainable options and also to create certainty for business to adopt sustainable alternatives without concern, and the competition law should be applied to them where it can. To look at the Australian example, our Australian Competition and Consumer Commission has a long history of accepting environmental and sustainability objectives and outcomes as public benefits in its administrative process called authorisation, which is a system of individual administrative clearances based on balancing public benefit and anti-competitive detriment. Claim benefits are tested carefully and must be significant, but they don't need to be mathematically quantified. There are many examples of the acceptance of environmental and sustainability benefits as public benefits, including cases back into the mid-90s, like DuPont and Tyco, which I was personally involved with as a lawyer, where the benefits were efficiency gains, but they were closely linked to significant environmental gains, where a joint venture superseded an existing sodium cyanide plant technology with something more efficient and environmentally sustainable. And there were significant reductions in carbon, nitrous oxide and greenhouse gas emissions. And the use of heat generated in the initial stage of the process was retained and recycled for use in internal plant operations. There was also a reduction of 70 to 80% of solid waste, which was currently going to landfill, and that was they were all accepted as public benefits, overriding significant anti-competitive detriments. There's also been a more recent merger case in the last 12 months where transition to renewables, the speed of transition was quicker with the merger, and that was accepted as a public benefit, outweighing, I won't go into it, it's fairly complex, but outweighing the anti-competitive detriment of the merger. So there are also other examples in relation to collaborations, battery stewardship councils, recycling between competitors. But we haven't yet had any authorisations for abuse of substantial market power, which is our equivalent of abuse of dominance. The ACCC has focused on greenwashing. It's got draft sustainability collaboration guidelines, which are being amended at the moment. And the ACCC's submission to the current Treasury Competition Review, which is pretty large in Australia over 2 years, has talked about enabling competition and consumers to drive the green transition as one of its main objectives in enforcing the Act. But it also argues there that it's important that conditions for competition are preserved while proactively identifying sustainability issues. So what I'm trying to say is, I think that the Australian regulator has really good and long-standing credentials around sustainability. But unlike the EU, we don't have constitutional guidance on sustainability, although there have been a number of policy statements by governments. Now, looking at our Australian provision on equivalent of abusive dominance, which is called misuse of market power, the stated objective is to deal with unilateral use of market power damaging the competitive process, and it requires a link between the conduct and the lessening of competition, but the link has been lessened in recent amendments. If then sustainability was raised in a merger situation, it would certainly be considered carefully in the context of merger authorisation. We're likely to see more merger authorisations going forward with sustainability public benefits. And I think if the opportunity arose, the ACCC would be very keen to apply the misuse of market power provision as a sword in a situation involving sustainability where it can. There's not much law on the new provision, and so we're a little short of detail on that. But I liked some of the examples that have been raised, and I can see that they would quite seriously be considered, such as sustainability as an indicator of dominance in the circumstances which have been discussed, of quality, and in circumstances where a dominant entity deterred implementation of sustainable initiatives. And of course, then we've always got the possibility of authorisation. So I see that these things are a possibility, but I don't think we are as advanced as you are in the EU on our thinking in relation to abusive dominance and sustainability. Thank you.
Thank you very much, Deborah, and also for providing us with the Australian perspective. And now it's the turn of Michelle.
Hi, everyone, and thank you to the OECD, the ICC, and to Simon for inviting me here. I am bringing a slightly different perspective because my perspective is not just purely kind of academic, and I'm not also bringing the kind of enforcer perspective, which we've also heard. I am a campaigner and also a kind of writer on some of these issues, and have founded Europe's first anti-monopoly civil society organization. So I'm also thinking about this from kind of a broader civil society perspective. And I have just 3 brief points. The first point is to point out a blind spot, which is that we are kind of proceeding into this area with very little academic work behind us around the 2 textbook market failures of neoclassical economics. On the one hand, market power, and the other, negative externalities. Hardly any research, and I would love if you can find some, please do send it to me because I've looked. Very little research on the connection between these 2. How do market power and negative externalities actually interact? We don't have that kind of, it's a kind of conspicuous vacuum, I would say, in our knowledge. And I would say that's driven by a lack of interest in, what are the connections between dominance and monopoly on the one hand, and on the market failure of negative externalities on the other. And in place of that kind of rigorous level of analysis, I think instead what we've done is import a couple of mental models that we bring kind of in our own heads to this discussion. The one which I happily haven't heard here, but I'll raise because I've heard it in many other fora, is the idea that dominant firms are good for sustainability because they have excess profits and they can therefore plow those excess profits into sustainability actions. So the kind of big, powerful company, we want more of them because they're going to kind of save us from ourselves. That to me is in flagrant contradiction of kind of common knowledge and common sense. And you can kind of open the newspaper and read any number of examples of why that's not the case. That I think is not at play in this discussion here. What I've heard is a couple of other points, which I think start to kind of veer towards that direction. So we heard earlier in the presentation from Elise, this idea that, which is very commonly held, that there is no causality between dominance and sustainability. We also heard Vera suggest that we shouldn't be looking at harm as evidence of power. And I'm kind of paraphrasing both of them, so they may want to correct me if I've got either of those wrong. Now, if I look back to the European law definition of dominance, which is the ability to act independently of suppliers, consumers, and customers, I would say that it doesn't really make sense to me that we wouldn't take into account the harms in order to try and understand what is the nature of power, and why we would presume that there's no causality between dominance and sustainability or unsustainable activity. And I would say, on the other hand, that actually evidence of harm is evidence of an ability of a firm to externalize its costs. We have to precisely look at the evidence that we see surrounding the firm's activities to understand the nature of power for that firm. And happily, Simon laid out in detail that the law doesn't preclude us from those kind of more commonsensical notions. So the first point is we have a blind spot around market power and externalities and the link between those 2. Part B of that first point is also that we have an absence of research, really, or kind of linking of research. There is more research in political theory around the connection between size and externalities. So there, political theorists will tell us that the bigger a firm is, the more ability it has to potentially lobby government, influence its regulatory environment, but affect its own ability to externalize costs and internalize benefits. So I think that those 3 things, market power and size and this negative externalities, we need to be kind of much more circumspect and consider what mental models we're bringing to our analysis when we start to think about the issues that we're raising here. And I suspect that if we do that, we will find many abuses of dominance that we may want to go after. So that brings me to the second point, which is what happens when we consider the firms for which the abuse or the negative externalities are actually part of their business model. So we cannot just look at their conduct, because actually, if we take fossil fuels, for example, many of the things that we would consider, many of the things that Simon mentioned in his initial remarks, these are actually, this is the product. This is the business model. It involves these negative externalities. Now, typically, we would say that that means this is, we should be leaving these issues for regulation. If that's the case, then competition law would have very little to add, because actually, we would only be dealing with the most marginal cases. We would not be dealing with the sorts of levels of emissions and biodiversity loss, etc., that are going to make a difference to the kind of climate catastrophe. But I would just say that if we look to another sector where that is also the case, where one might say that the negative externalities and abuse are part of the business model, which is in the case of big tech, we see a model where we have decided in Europe to take a kind of regime-wide approach, where we have the DMA and we approach the entire sector. Incidentally, the threshold triggered by size, because we do think it's relevant there. And we start to impose responsibilities on those firms based on their size as a whole sector. Now, I think that many of us could think of sectors to which we may want to apply a regime that thinks about what is the special responsibility of those dominant firms and starts to lay them out. Again, we may have too many sectors to consider, which brings me to the third point, which is of prioritization. Now, I might ask, how many webinars do we think are happening around the world today about climate change? And how many of them will make a substantial positive difference to us addressing climate change? I think the problems are enormous. We shouldn't kind of be, sinking back into doom and gloom, but I do think that we need to think about those reports like the IPCC's report to guide us into how should we think about which sectors to focus on, which sectors should we channel our efforts into. Because the reality is, and we're here talking about 102 enforcement historically has been pretty marginal. I do not think that we can say the existence of 102 in the treaty has, for the last 50 years, done very much for dominance in Europe. In fact, we've seen over the same time, massive increases in kind of dominant firms and concentration across industries. So I think we need to be kind of pragmatic about what we can achieve. And I think what we should at the very least do is think about what we're doing on with the other hand. So we've heard the incoming commissioner talk. I mean, mostly what I've heard around sustainability has been on state aid. So if we are going to be giving government funds to potentially dominant firms, or to big firms, or to firms that we want to become big, we need to be thinking about how can we ensure that those public funds are not then used to finance abuses of dominance that then hurt the exact people that we're trying to help. So those are my initial comments, and I look forward to the rest of the panel.
Thank you very much, Michelle. Also to have introduced some interesting questions and also some doubts on this relationship, and also on the definition of market power. You talk about size and also concentration of capital. I mean, all things that we will discuss in a minute. But I would like to give the floor now to Marty Peter Schinkel for the last initial remark, and then we will start our discussion.
Thank you, Giorgio. Thank you for the invitation. I just returned from Brussels. There's so many exciting things going on in our area. The Draghi report we were talking about, and the need for the new competition tool to help European market integration. But this one is also still on the agenda, and importantly so, because of course, let me begin by saying climate change is the biggest externality ever, of course, because all this pollution, it doesn't matter where in the world you do it, and also not where in history it's done, it just accumulates into a big problem that we should try to do something about. But my little contributions, and I have tried to contribute a little bit to the literature on the relationship between market power and externalities or sustainability efforts, has been really that we should keep sort of a fundamental set of questions, that we should keep our eye on the fact that competition law is about protecting competition. And so the question is, what is the relationship between competition and these sustainability issues? And there, my previous points have been, and I will not dwell extensively upon those, but I do still sense there is a collaborative mindset here in particular. For example, with Elise, she emphasized that. So it's very important to think about whether agreements are going to deliver incentives that will actually make the parties that you're going to accept such an agreement and allow them to get together to actually do something about sustainability. And the problem is the incentives are typically not there. It is rather, even if there's only a little bit of willingness to pay with consumers, it's rather that competition is driving companies to invest. And so restrictions of competition are not going to help very much. And this is, as Michelle already pointed out, this is anyways very much tripping around the fringes of the problem, because there's much more superior ways of dealing with sustainability problems and climate change than trying to let the companies do it. That therefore we should be careful that we do not crowd out with this idea that the companies are going to take care of it collaboratively. We crowd out the real actors, the governments that should take care of this, right? And Wolf starts with a market failure, or with a regulatory failure that now the competition authorities, also by the way, authorities, should now fix. But that I think is really, I mean, we're really losing the game if we have to be there. So we have to be careful there. And also, therefore, I'm glad that we're now talking about 102, because when we talk about 102, I would say here we can think of maybe restrictions of competition that do harm. And so I certainly see exploitative abuses and also exclusionary abuses, killer acquisitions in the green domain, for example. So companies that do not clean up their act because they're not under competitive pressure to do so. However, we should be careful that then the theory of harm should be one where competition would make them clean up their act. And so it cannot be just a paragraph 5.5 reference where we say, okay, it's a dominant firm, which seems to be Simon's line. It's a dominant firm. Now I have my green goggles on. Dominant firms cannot have a special responsibility, and that now yada 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 also implies they cannot pollute. It should be a theory where the idea is that the restriction of competition, and we show that this is very likely to be an incentive, will get companies to not clean up their act, to not invest in sustainability, for example. And there's some papers that say that would be the case. Roman Inderst has a paper where he says that monopolies would do all efforts to avoid externalities. I don't believe that is true. I think we can easily create situations where companies would not clean up their act if they have market dominance. So I'm happy that the debate is now on 102, but we should still keep in mind we should see actually that there's a logical inconsistency if at the one hand you're going to argue restrictions of competition in the 101 domain are going to deliver green, and now you're going to say, but wait a minute, competition in the 102 domain would have delivered green, and so the fact that the companies, including rivals that have a cleaner, greener way of production, is actually now doing sustainability harm. And so, and maybe I should then close that. So that there's this short shield analogy that Simon is pushing, and I think it's a bit that's misleading because those are not complements. It's a sword matter. The shield is not really working very well. So we should be careful. So of course, this is sort of the knight picture with Simon being a knight, I suppose. We have to be careful that don't trip over the sword and trip over the shield and fall into your own sword here. Attack is the best form of defense, let's put it that way. So let's close. I think that absolutely it is interesting to think about 102 exploitative abuses and exclusionary abuses as potentially pollutive. And I would be in favor of the Commission developing this further. It was said, Vera said that the Commission opens the door, but really it's only a footnote, as Wolf pointed out, of course. So I think it would be interesting to do more in this domain. It should be possible to take the lead there, but the principle should always be that deviations of competition are harmful, also harmful to the environment. Thank you.
Thank you very much, Martin Peter, and thank you everyone for these initial remarks, which have introduced a number of interesting topics, which I think it's now the right moment to explain and go into more details. So let me circle back for a moment and start asking the panelists a question which may be relevant for the audience. So why are we having this discussion today? We heard already many things, but perhaps you want to elaborate more points. So what is the potential relationship between market power and the rules prohibiting the abuse of dominance with the climate change and sustainability? So let's say the sword angle. So happy to, if you can elaborate some of your points that you mentioned. And we can start with the same order with the Wolf, please.
Wolf, you're on mute.
I don't see it.
Sorry.
Okay.
Start again. For me, the point is that dominant companies clearly have a role to play regarding sustainability because of the impact they have on society. And that's why I believe the main issue is not just market power, but the resulting special responsibility of dominant undertakings that requires them to think proactively about respecting norms, including sustainability norms. Earlier on in our preparation, we also discussed whether this requires new theories of harm. It may well do. I don't think that is a problem, as there is no objection against developing new theories of harm in competition law, just as has been done in the digital area, for example, with self-preferencing behavioral aspects and the role of indirect network effects. And as I think I mentioned in the Dutch IT refurbishment case, we want to combine exploitation and exclusion, which is not unheard of in competition law, but may also involve a new theory of harm. Another example may be the context of predation, where firms taking on board externalities should be considered as efficient competitors, even if their products are as a result more expensive. But I think it's a more serious problem, which Michelle also pointed out, is that the enforcement of 102 is time consuming and frequently unsuccessful because the bar for its application is so high. And the so-called new economic approach is responsible for much of that. And in that context, new theories of harm may find it even more difficult to clear the judicial hurdle, which is why I think that's a general issue that may plead in favor of introducing a new competition tool, both at national and EU level, also to solve sustainability issues with the competition dimension. Thank you.
Thank you, Wolf. And Deborah, what is your view on this?
Look, I suppose I think I'm more conservative on this. In Australia, we don't have the special responsibility requirement of dominant corporations as you do in the EU. But we also have found it very hard to enforce our provision, and that aligns with what others have said about the utility of Article 102 generally in the EU. What I think is that there is better traction for issues of sustainability if they are incorporated into existing concepts with a broader range of thinking about them. So we look at them, we focus on quality, we look at how they factor into market power in a particular case, we look at how they factor into exclusionary conduct, for example, in another case. And I think part of those sorts of uses of the provision depend on some consciousness raising and the suggestion of possibility to those who are already working in the area, and broaden your thinking on all of this. But I don't think we have to invent too many new things, because everyone is focused on climate change and issues of sustainability. And I think if we work harder at opening people's minds to the use of existing concepts in this context, it could work quite well without inventing too many new things. So that would be what I would say.
Thank you very much, Deborah. Michelle, what is your take? We heard many things from you, also not in a similar direction, so you might want to elaborate a couple of points.
Yeah, thank you. I think actually Martin Peter really clarified an issue that maybe some of us are dancing around. Certainly, it's a real kind of point of division for me, which is that this idea that competition law is about competition. And so all we should be thinking about is, what is the restriction of competition? Has competition been harmed? Is there a party that has been excluded, etc.? And I think I would love to practice competition law in the world in which we only need to care about competition. But competition is only meaningful if you don't have massive concentrations of power. So we're not in that world. We are in the world where we didn't enforce against competition, anti-competitive conduct, and we haven't done it for about 50 years properly. So in this world, we need to think about dominance. We need to think about power. We need to think about bigness and size. And then once we've dealt with that, we can get to kind of niche restrictions on competition. And because we need to care about dominance and size and market power, that's where 102 has its contribution. That is the kind of contribution that I'm talking about, which is, how do we release markets from the power of the biggest firms in the world that are the biggest emitters, the biggest polluters, the ones that control what food is sold around the world, the shipping routes, all of those sectors. And we can look at the big tech firms and the energy use that is implied in the AI boom. Like, all of these firms that have dominance, kind of, it's not really up for question of whether some of these companies are dominant. The question is, like, where is the abuse? And we kind of blindside ourselves to our own kind of common sense. So I think that we should be thinking about the contribution of 102 in that context. And I would say that there's a lesson that we can learn from what we have seen evolve in the intersection between competition and sustainability around green collaborations. And I hesitate to bring out green collaborations when Martin, Peter, and Simon are in the room, because they obviously have a lot to say on those topics. But I would say that there's two lessons. One is the green collaboration point of interest was stimulated originally within civil society by a concern around big companies saying that they couldn't voluntarily act. And I'm always concerned when we are relying on the graciousness of big companies to act, because most companies do not have that within their core articles of association, that their mission is to do good in the world. And even if they did, I wouldn't really believe them, because the corporate form is built to accumulate property and power. So we must be, I think there are many big companies that have done many good things, but I don't think we can assume it as a model. And then the second point is that discussion around green collaborations has got into an excruciating level of detail around what should and should not be allowed under the law. But I do not see a huge upsurge in incredibly beneficial green collaborations. And I believe that I've definitely heard at least Martin Schnupp at the Dutch Authority say that there hasn't been really like a kind of stampede of people coming to the door asking for guidance and approval of their collaborations. Therefore, I would ask, what is the quantifiable or kind of direct link between the efforts in that space and climate change? Like, we can definitely feel good about what's been done there. And I completely agree that we should allow green collaborations where they do not restrict competition and enhance power. But again, I'm like a broken record. I'm going to say the problem is that we have to deal with the independent manifestations of power as well.
Thank you very much, Michelle. Martin, Peter, the floor is yours.
Yeah, thank you. Yeah, so on these collaborations, I mean, they are red herring. I think we have really lost too much time debating those, although it comes back now again. So maybe there were lessons. I've been in panels with the big business companies that wanted to have compressed deodorants or biodegradable candy bar wrappers. And so really minor contributions, or taking off the plastic handle of the six-pack for soft drinks. I think that's the only real case that Dutch Competition Authority can boast. Well, there's another one involving oil companies where if you look another time, then it's really problematic. So I'm with you that yes, we need to go after dirty dominance. So market power can certainly be a problem. If you talk to environmental economists, what do they point out? They point out the green paradox. So there's what will happen if we're going to let's say finally put taxes on CO2 emissions? Well, then so what happens if there's the threat of governments doing this? then there will be stranded assets. And so the companies that own the contracts on, let's say, pumping the oil, they hold these assets, they've paid for it in the past, and now they see their value decrease. So they have a huge incentive to lobby the government to try to postpone this kind of legislation to being put in place. And then in the meantime, that's the green paradox, in the meantime, quickly pump up as much as they can now. So bring all the dirt to now, because that's where it's most valuable. Or, for example, they invest in storage, CO2 storage, so that they will later have a longer, that's actually the other case of the Dutch Competition Authority, where they later will have a little bit more prolonging of their emissions, because they have this storage now where they do CO2 storage. So we have to be really careful that these stranded assets, the interest of big business there introduces this green paradox. And if we are prolonging the real solutions to these problems, and I think the debates that we're having here so much on the fringes that we run the risk of doing that by crowding out further government intervention. And we've seen that in practice in the Netherlands in the micro cases. The chicken case was all about the government not wanting to regulate, throwing it over the hedge to the Dutch Competition Authority, the chicken of tomorrow. So then we are making things worse. That is my concern. The incentives are not there for companies to do it collaboratively, and the big companies with market power, they have an incentive to lobby and use their power to prolong introduction of the real measure. So therefore, I think competition authorities may have a role in this domain as a sword. Of course, attack is the best form of defense. So as a sword, and then go after these companies for these kinds of dirty abuses that I think are absolutely there. So I think it's a no-brainer. The examples that Michel gives also. That's a no-brainer that companies would have all sorts of incentives to avoid the cost of making the transition and hang on to their old technologies. It's actually also what cartels have done to tie the knot. If we look at the trucks cartel, one of the aspects of the trucks cartel was it was lobbying, but also collectively postponing the introduction of Euro norms, and so that they could use their dirty technology a little bit longer. The AdBlue cartel, same thing. And so we see in the cases that we've investigated that there clearly is dirty dominance collectively, or when companies have market power. And so, again, I think this is a relationship and a very important domain where DG Comp could be leading with an extension on the guidelines.
Thank you, Martin Peter. And I would like to involve also some of the three speakers. I understand, Simon, you want to comment on what you have heard so far.
Just one comment, really. I mean, to my mind, it's a very academic and largely philosophical discussion as to whether or not, on the one hand, the big, powerful companies are bad and cause the most harm, or whether or not the big companies, because they've got the most resources, have the most potential to do good. Perhaps they've got less competitive pressure, and therefore it's easier for them to do the right thing. At the end of the day, that strikes me as a highly theoretical and ultimately unanswerable question. And in any case, you don't need to show causality between dominance and the abuse, which is the mistake a lot of commentators have said there's no necessary causality between the two. My point will be a pragmatic one. It's case by case. Sometimes you want to ensure that you're not inhibiting good actions by big companies, but also you particularly want to focus on those big companies because, as Michel alluded to, and we discuss it in a joint paper, 70% of all greenhouse gas emissions since 1988 have been caused by 100 top companies. So purely from an efficiency point of view, it makes sense to focus on those big companies because many of them will have dominant positions. You can be a small company have a dominant position, but it's usually it's the big companies that have dominant positions. And in any case, we're talking about an existential crisis. We need to use all the tools that we've got, and we have a moral obligation to use them. So we should certainly be thinking about using these provisions. And I very much agreed with what Deborah said. We need to broaden our thinking, even to the extent that we're just using existing tools.
Thank you, Simon. And I also would like to involve, we heard a lot also of interesting comments on the draft 102 guidelines. So I think it's the time also, before I go to my second question to the panelists, to involve Vera, if you have any comment what you heard so far, and then in particular on the guidelines, on the positive and negative comments.
Yes, no, clearly. The critic that has come forward quite clearly is that disappointment as that there is no sustainability section in the guidelines. By way of comparison, I hear what Simon said about the fact that well, there has been no precedence also at the basis of the horizontal guidelines, but there has been a consultation which pushed forward. Our stakeholders really demanded some clear guidance on cooperation. That was really something that was driving the discussion and the debate. This has not happened in this case. We haven't, I mean, apart, of course, there are discussions, but they are, if you will, a bit more on the academic side. So there hasn't been such a demand for a broad discussion on this topic. About the hooks that there are in the text, it's not just a footnote. If you only look at the sustainability word, yes, maybe it's only mentioned once, but there are other openings, as I mentioned before, in relation, for instance, to objective justifications, which is one aspect that's been, discussed and raised quite clearly. There is opening, and I don't think the text as it is of the guidelines would impede us from digging into it, whatever the case come forward. If dominant companies come forward with type of justifications linked to sustainability, we could consider it. I've also seen in passing in the comments references to the Corporate Sustainability Due Diligence Directive. There again, if you look at the text, there is also indications in the footnote really that, if there's legal obligations to act in a certain way, certainly the attributability of the conduct to the company is out of the picture. If the company has some autonomy to act, there kicks in again the special responsibility of a dominant company to not to engage in conduct that hampers effective competition. And there again, there must be ways to abide by the rules if there is room for maneuver that allows requires a dominant company not to impede as much as possible competition. Also here, one point that I beg to differ with Simon about is he mentioned at the very beginning of his presentation, dominant companies just have to have a special responsibility to behave well. It's a bit different. It's not to not to impair effective competition, right? So the standard is a different one. What we are concerned about is competition. It kind of links back also with what Martin Peter said. Indeed,
I agree with you on that. I'm speaking very generally there.
We have to be very careful, to the link with competition has always to be there. And this,
I agree.
I think all the examples we've looked at, I'm trying to link back what I've heard and the critics. I think all the examples we've heard show that you can factor in this dimension in the assessment. What I'm slightly concerned about is the idea that I'm pretty sure we don't mean that, but we shouldn't try to put a label on dominant companies. They're big, they are harming, therefore there must be an abuse somewhere. Obviously I don't share this kind of this tendency. We need to be very careful and do. As an authority, we have responsibility to analyze case by case on its merits and see how it goes. So I see there is space for development of the practice, but I would also like to say that indeed I like the fact that and I like that you more than one of you raised it, that indeed sustainability aspects can come into the picture when you looked at the competition of the merit dimension, which is a very important dimension. And this is something that I hope that I would encourage to submit observations about during our consultation. If there are some dimensions on competition on the merits that could be explained under the umbrella of sustainabilities, we are happy to receive them and reflect and to discuss about them. For instance, this is something quite interesting, and it still remains within the area and the tools that we are used to and are based on the case law. Just to circle back again to what Deborah was saying. I finish here, Giorgio, because I might have been gone a little bit in all directions.
Thank you, Vera.
So, Giorgio, Giorgio, I sense that calling something an academic question is a disqualifier a little bit. That must be wrong somehow. The question whether companies have an incentive when they have to, for example, do R&D, or in this case, clean up their act when they are big or small, it's a classic, it's a classic problem. It's a classic issue in economics of the inverted U. You cannot just call that an academic question, leave it at that. So that's key.
Thank you, Martin Peter. I mean, for clarifying what you heard. I mean, Vera, I guess was also trying to explain and elaborate, all the less positive comments that she received throughout this hour. And I think now it's a good moment to shift. We've heard many times talking about objective justification, and also many of you have mentioned the dual role of sword and shield, with Martin Peter being more or less optimistic about the shield side angle, and perhaps this is the right moment to elaborate. So let me move to the second question, which is about efficiency. So how can potential efficiencies related to sustainability practices be assessed? And so how can environmental consideration that we have touched upon now this afternoon can be seen as objective justification? We have also a question from the audience on this particular topic, which I will then ask at the end of your intervention. So let me start again with Wolf, please.
Thank you. I don't think this is the time to debate with Martin Peter on the value of agreements and sustainability, but I do want to contradict that there are only 2 cases before the Dutch Competition Authority. I personally worked on at least 5 which were published, and I think at least 10 have been overall in terms of informal guidance. Now, to move on to efficiencies, in the first place, I think the issue of measuring efficiencies under 102 is not significantly different from measuring efficiencies under 101, even though there are probably fewer examples of successful efficiency defense under 102. And as I mentioned earlier, I'm in favor of a horizontal approach to both 101 and 102 to avoid a needless proliferation of competition standards. So I would be in favor of introducing the 3 categories of individual use and non-use benefits, as well as collective benefits that were introduced under 101 by the horizontal guidelines under 102 as well. And that said, I would welcome a broader general view on the collective benefits that can be accepted. That brings us to the discussion on the fair share within the relevant market and whether that requires full compensation of the consumers there. I believe that it doesn't, and that it's reasonable that the polluter should pay and an objective benefit would suffice, but that's probably not really the topic for today. The second related issue is what is an efficient competitor when we're talking about efficiencies. In this context, I want to repeat that I think the cost of externality should be considered. And that means that firms that have higher costs because they incorporate the cost of externalities in their cost should not be regarded as less efficient. And that should include the context of predatory pricing, margin squeeze, and exclusionary rebates. This requires further thinking, I believe, including in the 102 guidelines. So I'll leave it at that.
Thank you, Wolf. Deborah, what's your take on efficiencies and objective justification?
Look, what I have very little to say on that, except to say that under the Australian law, efficiency is really only considered under our authorisation process as a public benefit. So we don't have the justification process that exists in the EU. So I don't think I can add anything useful to the discussion on that point. Thank you.
Thank you, Deborah. Michelle?
Hi, I don't have a huge amount to say on efficiencies, so I'm going to use or maybe abuse my privilege here by responding to a couple of the other points, including the point that is going on in the chat, which I think responds to something that I had alluded to as well about the dearth of cases around green collaborations that have come forward. My point wasn't so much that there haven't been cases that that have required approval or have achieved it or have gone forward. My point is the link between what difference this has made to the existential problem of climate change. I'm yet to be convinced that those green collaborations that have gone forward A, would they have happened anyway, and B, whether they will make a massive difference. And I will also just use my time to give 2 quick points, which are mostly directed towards Vera, because the European Commission is obviously actively looking for feedback at this moment. One, I would say that we should not wait, because I do not think that you will ever see substantial demand from stakeholders, if by stakeholders we mean businesses, for guidelines on 102. It is not the same as 101. On the collaboration side, these were companies wanted to do something, so they've come to the Commission for guidance on how they could do something they wanted to do anyway. On 102, a tool which is hardly implemented, I don't think we're going to get a clamoring of business saying, tell us what are the bad things we're not allowed to do, because right now they're like not being looked at. So why would you get the eye of Sauron to come looking at your business and investigating it? And then the second point is, I totally get that the Commission is not in a position to take a position around, and this is also might be a personal thing around, whether big companies are good or bad. As Simon said, that's an unanswerable question in many ways. And for the Commission, there needs to be a case-by-case basis. What's the mandate, etc.? What can the authority do? But I would say that models like the DMA relieve the Commission of having to consider, is big or bad, is it, whatever, and to dive into what are the responsibilities that these firms should have. Now, I will say that I was also a critic of the DMA in that it should have, in my view, have maintained breakups as a remedy at the outset, create governable companies so that you can actually enforce against them first before you try to build a relationship with them. But that is another topic.
Thank you, Michelle. Vera, just a second. I want to give the floor to Martin Peter to provide his view on this, and then I come back to you. Please, Martin Peter.
Okay. Yeah, so I subscribe to the point that many of these cases are quite minor. That is actually that's where the examples of the plastic handle. Anyway, I mentioned all of those. So on the question of efficiencies, for an economist, it's a no-brainer here. Definitely, environmental economics can be brought in, and we can measure efficiencies in the form of maybe quality improvements, as the way in which the Commission formulates it, but also efficiencies in measuring externalities and how they might be reduced. This is a huge area of environmental economics. It is very well developed. Nobel Prizes have been awarded, and so that kind of analysis we can do. It's not the key question in my mind, I think, on the table, but we can do it. And if we then go back to one comment that Wolf made, the point, of course, of restricting the assessment, because it's important if we do the assessment, just like when we do it in merger efficiencies and its cost efficiencies, we have to be skeptical and aware that there might be overly rosy claims made by the companies. And so we have to carefully assess this and see if it's true. And then if we look at who can we bring in on the side of the benefits, and that's where the consumer compensation requirement is key, I think, and I'm happy that the Commission kept that closed in 101, and it should also stay closed here, I think. If you're going to bring in, of course, there's going to be, and so of course there's going to be all these externality benefits all around the planet, because these environmental benefits are worldwide potentially, right? But the problem is if companies do not have an incentive to really do something collaboratively or really do something when they are merging, then if you're going to allow all these benefits on the benefit side, they can get away with a little bit of green because it's being multiplied by the whole wide world, and so then the scale will tip towards allowing them something which would be really a minor contribution. So we can measure it, but we have to be very careful that we don't believe it's actually going to happen without safeguards there.
Thank you, Martin Peter, and I mean also for clarifying that it's possible and especially for you as an economist, and to measure them. I guess from a legal perspective and agency perspective, we also sometimes think whether the test is actually the same. We are talking about these externalities, which may have a different nature. But perhaps I want to give the floor first to Vera, and then Simon that wanted to also comment on this topic. Vera, please.
Yes, thank you, Giorgio. Just to comments in reaction to Michelle's point. It is not true in my view, and I think that the track record of the Commission shows that we haven't done anything on 102, at least in the past 15 years. You've seen there's quite a number of, I believe, at least 30 decisions on 102. So I don't believe that this is a correct picture of what has happened so far. And on top of that, it is in reaction to the call for evidence. When we announced we would do guidelines, companies did. And of course, associations in their associations and lawyers, there is a need for guidance because the case law is confusing. The case law is articulated, is complex. So there is a need of guidance. Companies want to see what are the limits, the boundaries of their behavior. So it is not something that is very different from, as I say, in terms of demand for guidance as was happening in the horizontal guidance. Second thing, on the tool, and the new competition tool for sustainability that both Wolf and Michelle suggested, I would be a little bit careful there. The DMA has been come in the picture to address structural problems in the markets, digital markets in particular, where there are companies, there are gateways between two sides of the market. I find it difficult here to envisage a similar type of approach for sustainability. There is a lot of legislation that protects, that has as a purpose environmental protection. And as you've seen also in the priorities of the Commission, a lot of attention is given to to the state aid tool, as tool that is supposed to push investments in the right way, in the right direction. Attention is given to mergers a lot also in this field. So I think we should be thinking very carefully about what could be potentially a tool also for addressing sustainability. Thank you.
Thank you, Vera. And now the floor is for Simon for comment on efficiencies. Let's try to be short as we are almost running out of time.
Well, two brief points. Yes, my first point is indeed I wish we'd stop talking about efficiencies because it's not the subject it's not the relevant terminology or topic really. Of course, many things done which are more sustainable will be more efficient using less raw materials, for example, but it's misleading using that term because in a 101 context, the term is benefits, which is much wider. And it's the same here. When we're talking about objective justification, that is a much wider term than efficiencies. And the Australian term of public benefits is similarly wider. So whilst I'm a great fan of efficiency, I don't think it's the right term we should be using. And it sends people down a narrow pathway. Second point is, when we're talking about a shield, well, all I'm talking about there is being careful not to inhibit where companies are doing something good, and you may be skeptical as to whether they will do anything good, but where they are, that they shouldn't be inhibited by that, by it being misclassified as an abuse. And yes, we can talk about objective justifications, but in many instances, the sort of thing I'm talking about, you don't get to the first stage of it being an abuse. If you do, then yes, you go through the analysis of objective justification. But be careful that we don't get over technocratic on that. And I could start debating that because it's the area is being distorted by cases like Healey, but I won't go down there. Primary point is there is not an abuse in the first place, so you don't need to consider objective justification.
Thank you, Simon, and for this clarification. And I want to link it to the question that we have received. So perhaps you can also reply because it's linked to objective justification. Before your closing remarks, let me open the chat and I will read it.
Can I just clarify that efficiencies are not a narrow concept in economics. Okay, so all these things that you mentioned, Simon, they're fine under that consideration.
Economists often say that, well, then stop using the term if that's what you mean. Say what you mean. I agree with you.
Economists think in terms of efficiencies, but then they have a very wide welfare concept behind it. So don't worry about
the rest of the world. The real world doesn't.
So a middle ground can be to use both words or something like this. But let's go to the question because so that we can then close the session. I was opening the chat. 1 second, this is for Simon. So if a dominant company wants to cut off supplies to a dirty customers or stop buying from a dirty supplier in order to meet the transition goals, is there an objective justification? If probably yes, okay, if the party is not a competitor. But what if the dirty company is a rival, refusing to transition? Surely there should be then a defense. What's your view, Simon, on this?
Well, I hate to dodge the question by saying we'd have to look very closely at the facts, but my instinctive reaction is that they would probably have a good defense, because what they would be doing would be in line with a clearly established public policy. But I really would need to look at that case by case. But instinctive reaction is they should be on good grounds. And it's a classic sort of case where seeking guidance would be helpful. And indeed, having guidance in the draft guidelines or a steer would be helpful.
Absolutely. I mean, guidelines and cases, we said, I heard so many times today that will help to clarify some of the points we discussed today. And any other wants to reply to this question with a different view, or we move on to the final remarks? Okay, so Simon, the floor is yours to close this session.
Okay, well, I'll be brief. And I just want to stand back from this and just a few very high-level points, because we've got apparent disagreements on one or two things, but just the context. The first point is that often when we're talking about sustainability, we're talking about climate change. Some of the more subtle points, maybe I have more sympathy with when we're talking about other aspects of sustainability. But let's face it, the central issue here is the existential crisis of climate change. And in that circumstance, we have an obligation to use all the tools and policies available. Second point is that competition policy can and is playing a part. We used to argue, as somebody said, I think it was Elise, we were debating that a few years ago. It's clear that competition policy can play a part. My third point will be, therefore, there is no inherent reason why the laws governing monopoly power, to use Michelle's sort of primary term, or Latin Australia, or the abuse of dominance, to be more technical, cannot be used as well, where it is because it is a relevant, powerful, and flexible tool. And yes, one can be skeptical as to whether or not it is done, as Michelle is, as to whether it has achieved very much, because market power has continued to increase, or certainly industry power has continued to increase. But that's no reason to give up. I would say that's a reason to intensify and adapt our thinking, to pick up on Deborah's theme. And indeed, the law is developing in this area. And I welcome this ongoing debate, which is relatively new. And I welcome the Commission drafting guidelines in this area, and indeed would encourage and invite the Commission to be bolder in the sense of including sustainability to a greater extent than it is already. It needs to lead and consolidate and guide in this area. So really, I just thank everybody for participating in this debate. Thank my fellow speakers, and our panelists. And I would hand back to you on that note, Giorgio.
Thank you, Simon, for closing. And yes, we have arrived to the end of this webinar today. I wanted to thank all the speakers for their availability and intervention today. Also, Ori and Simon for making this happen, this webinar, and also all the staff of the ICC OECD who helped us in organizing and scheduling this webinar. So a big thanks to all, and